Hello, good afternoon, everybody. Fáilte. You're very welcome to our first webinar in a series of 6 webinars for stakeholders in the multi-unit developments and owner management company sector. My name is David Rouse, advisor with the Housing Agency, and we're delighted to have you all with us this afternoon. So thank you very much indeed for joining us. We have a lot of people joining us this afternoon for this first session, and they are logging in and joining us as we speak. So to allow them to do that, I would take the time in the meantime, in the interim, while people are logging in, to remind you that we have 5 further sessions taking place each Wednesday over the next 5 Wednesdays from here, if you like, to come up to 6, including today. The second session is on Wednesday, the 21st of July, on service charges and debt collection. The third session is on Wednesday, the 28th of July, which will cover MUD financial management and OMC accounts. The fourth session is on the 4th of August, which will cover company law for OMCs. The fifth session is on Wednesday, the 11th of August, which will cover the role of the management agent and the Property Services Regulatory Authority. And our final, and last but not least, our final session is on Wednesday, the 18th of August, which will cover sinking funds. All of those sessions take place live at 12:30 p.m. and we'd be delighted if you could join us at those sessions. A little bit about the Housing Agency. We operate under the auspices, under the aegis of the Department of Housing, Local Government and Heritage. Our offices are at 53 Mount Street Upper in Dublin 2. And part of the mission of the Housing Agency is to promote the building of sustainable communities. The full title of the agency is the Housing and Sustainable Communities Agency, and we work with the department, with local authorities, with approved housing bodies and stakeholders in the OMC, stakeholders in the housing sector to work towards that aim. Our timetable for today is our presentation on the Multi-Unit Development Act will start in about 5 minutes. We will have a Q&A at approximately 1:30, and we aim to finish up in and around 1:45, give or take, depending on the volume of questions. Some housekeeping matters before we go any further. First of all, if you have registered for today's, and thanks indeed for registering for today's session, if it's your intention to attend the further sessions, you must also register for those. Or to put it another way, registering for today does not get you access to the 5 subsequent sessions, so you do need to register individually for those sessions, and you can do that on our website with the details there. So it's housingagency.ie, the same page as you used to register for this session. Certificates of attendance will be available to all those who register and attend all 6 live sessions, and more details on certificates of attendance are available on our website and on the various registration and confirmation emails that you would have received, and we will attend to that matter when the series has concluded. We would say that the information and the guidance being provided in these sessions is intended for help and assistance for those in the sector. We would say that this is not the rendering of professional services and professional advice on individual circumstances. So where you have particular cases or particular issues with your own multi-unit development or OMC, you should seek the services and advice of a legal professional. We would note that this session is being recorded for future use. It's our intention to, in the future, upload all 6 recordings to our website and make those available to you. In terms of other housekeeping matters, we will have, as I say, a Q&A after our presentation, and we would ask you to use the Q&A function for that. If you have any technical problems in relation to sound or vision, please use the chat function, and you can message myself, or you can message my colleagues, Sarah Kennedy and Tara Doyle, who are operating in the background and who will monitor the chat function and bring to attention any problems with the session. Hopefully all will be well. To confirm that slides from today's session, both these slides and our presenter slides will be provided by email after the event. So you will receive those over the coming days. So there's no need to follow up with us in relation to that. So as I say, this is the first of in our 6 series of webinars, and the intention is to provide information, guidance, and support to those of you in the sector. And we have, as I say, a large audience with us today, coming from various different stakeholder sectors in the OMC and multi-unit development in the multi-unit development area. So we thank you again for your attendance, and hope that you'll find the sessions informative and of interest. And with that, I will hand over to I'll introduce rather our presenter on the Multi-Unit Development Act, and our presenter today is Nick Metcalf, partner with Mason Hayes and Curran Solicitors. Nick is indeed a solicitor himself, and he advises on corporate governance, statutory domestic mergers, finance restructuring, and general company law requirements. He's advised and acted extensively in relation to OMCs for the companies themselves and for members of OMCs, advising on the interaction between the MUD Act and general company law and corporate governance. So with that, I will stop sharing my screen now, and I will hand over to Nick. So Nick, if you'd like to unmute yourself, please, and share your screen, it's over to you, and thank you very much.
Thank you very much, David. Hopefully, everybody will be able to see my screen, although I don't seem able to move the slides on, so I'm going to stop the share and try again there. Bear with me a second. So here, beg your pardon, everyone.
No problem. Looks
good. There we go. Yes. Sorry about that. And thank you very much, David, and thank you all for attending. It's good to be presenting to you all. As David said, I am a partner in the Corporate Governance and Compliance Department of Mason Hayes and Curran, and in that capacity, I have done a fair amount of work, a lot of work with owner management companies. And therefore, I'm very familiar with the Multi-Unit Development Act, or the MUD Act, as I will end up referring to it, because it's a mouthful otherwise. The presentation will cover aspects outside of corporate governance, as you would expect that it would, including common areas transfers, some discussion around dispute resolution and the like. But I wanted to emphasize at the start that my practical experience is more around the operation of owner management companies. But should there be any questions about any other aspects, we'll be happy to consider those at the end. And just by way of introduction, it's worth noting, I think, that the MUD Act has been enforced for around 10 years. And it plays a fundamental role in the operation of residential and mixed-use developments. It does that through basically establishing a matrix of relationship between the developer at the beginning of the life cycle of development, and then the unit owners who ultimately end up owning the units in the development. And it does that through the owner management company, or the OMC, which we'll run as a theme throughout this presentation. And what I'm going to look at is how the MUD Act, generally speaking, sets up and reinforces that relationship between those three parties, with the ultimate aim, maybe more often theoretical than practical, but the ultimate aim of enabling a development to be operated for the benefit of the unit owners at that development through the management company set up on their behalf by the developer. What I'm going to start with are just a few definitional terms introduced by the Act, just to kind of set the scene as to what the Act applies and how. And the first definition I want to look at is multi-unit development itself, from the title of the Act. And those are defined in the Act as developments whose units share amenities, facilities, and services. So generally speaking, the common areas, which we'll touch on a number of times in this presentation, and which have no fewer than 5 residential units. Now, it's worth pointing out as well that parts of the Act, parts only, apply to developments with shared services and which have between 2 and 4 residential units. But in my experience, those developments tend to be fairly few and far between, and where they do exist, they tend not to have the same types of issues and same level of involvement as the more classical multi-unit developments with in many cases hundreds of unit owners and therefore hundreds of members. So the focus of the talk will be on the first type there of developments, those with 5 or more residential units. And the Act also includes what it calls mixed use developments, and those are multi-unit developments as defined above, which also include at least 1 commercial unit which is not a creche. So if the development in question has only apartments and a creche, it is a multi-unit development. If it has apartments, shops, bank, offices, and a creche or not a creche, doesn't matter, then it is what's called a mixed use development. The MUD Act still applies, provided there are still the requisite number of residential units. What the MUD Act does not apply to is purely commercial developments, such as industrial estates and business parks and all. So I mentioned the relationship which the MUD, which underpins the effectiveness of the MUD Act. And integral to that relationship is what the Act defines as the owner's management company. And it's worth spending a little bit of time on this, just because of a couple of things I'm going to say on this slide about what that company can and doesn't have to be. But first and foremost, each multi-unit development, as we've just defined, must have an owner management company to which the common areas of the development must be transferred. And that's dealt with in sections 3 to 5 of the MUD Act. And those provide for the common area transfer, but they vary as to the timing of that transfer. And the timing depends really on the sale of the units in the development relative in time to the coming in force of the Act. But the underpinning provision is that the common areas of the development must be transferred at some point to the owner management company. And notwithstanding its name, an OMC need not actually be a limited company or any kind of company. And section 1, subsection 3 of the MUD Act provides that an OMC can be an industrial and provident society, which is a type of body corporate. And by that I mean a legal person which has a distinct legal personality from its members or its directors. And by that I mean that where the OMC is a company or where it is an industrial and provident society, then by and large, and except in very rare circumstances, and one I'll come on to, the OMC's debts would be its own, and it would be difficult, very, very difficult to pass those debts on to either the directors or the members of the company or the society. But on top of that, the Act provides that an OMC may also be a partnership or an unincorporated association, neither of which are themselves bodies corporate. For what it's worth, I don't really see that a partnership could operate an OMC, really only because the legal definition of a partnership is 2 or more people who are carrying on business together with a view to making a profit. And as I'll touch on shortly, owner management companies are not operated with a view to making a profit. Their purpose is really to collect as much money as they need to keep the lights on by collecting the service charge and using it to maintain the development, and also to establish a rainy day or stinking fund. But it's not there to turn a profit and to return that profit to the members. But either way, with a partnership or an unincorporated association, which in this context would be a situation where there was no company or other entity which owned the common areas, but instead the common areas were owned by the unit owners themselves and operated for their benefit. In each of those circumstances, partnership or unincorporated association, the unit owners themselves would be the ones who would be personally liable for the debts of the management company. So because of that, anyway, the vast majority, and in fact every OMC I've ever dealt with, are companies. I dare say there are examples of the other types of entity which could operate them, but I haven't myself come across them. Companies tend to be fairly user-friendly, and they do bestow limited liability on the members, by which I mean, as I said before, that the debts of the OMC are for the OMC itself and not for the people who stand behind it.
Nick, I might just interrupt you briefly and ask perhaps to increase the volume or move slightly closer to the speaker. We're having a slight issue with sounds. Thank you very much.
Okay, apologies for that. I will try to speak, as David says, closer and louder, but please, if there continue to be issues, please let the panel know. It's just worth noting as well that the most popular type of company for an OMC is what is called the company limited by guarantee. And that is a type of company which does not have shares in its capital. So the classic type of trading company, its members would own shares, and those shares would be theoretically tradable. So the shareholder could make money from their ownership, and also the shareholder would be entitled usually to receive a share of the profits of the company. None of those are appropriate for an owner management company, especially in the light of what the MUD Act says about a member's rights there, which I will come on to. And so companies limited by guarantee, because they aren't allowed, or really there's no mechanism for them being able to make payments to their members. And because there isn't the added formality of having to transfer shares and therefore sign documents to transfer shares when people sell their apartments, tend to be companies limited by guarantee. And what that means practically for members, and it tends very rarely to come up, but the guarantee in question is a clause in the Memorandum of Association in the Constitution of the management company, which says that where a management company is wound up, the members are required to contribute or to guarantee a certain amount of money to the debts and liabilities of the company. Now, before anybody who may be a member of a CLG starts to be concerned about that, it's almost always a negligible amount. It's usually €1. I've seen it go as high as €5, but that is rare. And so if an OMC is being wound up, the members will have a few concerns, but one of those is not that the creditors of the company can come after them for any more than €1 in most cases. So I mentioned that the members of an OMC are the unit owners. And just to continue the discussion about the definitions in the Act, unit owners are defined as persons other than the OMC itself who hold the highest freehold or leasehold interest in respect of a unit in the development. So it's the unit owner, the apartment owner themselves, not necessarily the occupier of the apartment, if that occupier is a tenant of the unit owner. So tenants, whilst they may live there, don't get to be members of the OMC, don't get to go along to general meetings of the OMC, and don't get to vote. And the MUD Act provides that any owner of a unit automatically becomes a member of the OMC without anything having to happen, and without any, in fact, contrary to any provisions which say otherwise in the company, in the OMC's constitution. And the unit owners have a few rights under the MUD Act, but the rights which specifically relate to their membership of the OMC are that they have the right to receive a membership certificate, which is nice to have, but isn't necessarily essential. And also, and way more importantly, unit owners have the right to vote at meetings and on resolutions of an OMC. And we'll come on to a few examples of that when we look at service charges and sinking funds and the like later on. And what the Act provides is that residential units, owners of residential units, have the right to one vote per unit owned. So the provision in the Act is not one member, one vote, it's one unit, one vote. And there are also provisions for mixed use developments. So you'll recall those are developments which have commercial units as well as residential units, to apportion votes to owners of commercial units which are fair and equitable. And that's often done by reference to the amount of contribution to service charge made by the commercial units. But whatever voting rights are given to the commercial units, that should not, and in fact must not, vary the default position that all residential unit owners have one vote for each unit that they own. And the basic principle behind that is, I guess, the same principle behind the American Revolution. There should be no taxation without representation. In this case, the unit owners are the people who contribute the income of the OMC, and as we'll see, the OMC has the right to make charges of the unit owners, and so it is only both logical and correct that the unit owners should have the right to have a say in what those charges are. And again, we will come on to a bit of discussion around sinking fund and service charge and what the MUD Act says there a bit later on. David mentioned at the beginning in his introduction that there will be a further presentation in the series, which is forthcoming, on company law and owner management companies. And in fact, I will be giving that presentation as well. So this presentation won't touch very much on company law and corporate governance, save where the MUD Act specifically deals with it. But what I want to do is take a bit of time to explain where the MUD Act imposes extra obligations on both directors and on OMCs with regard to their members' meetings, which are over and above that contained in the Companies Act and in company law generally. And so one thing I want to point out at the beginning is something that the MUD Act doesn't say. And what the MUD Act doesn't require any qualification of the type of person who is a director of an OMC. So contrary to, I think, maybe a popular conception, directors of the OMC do not have to be members of the OMC, although, as I've noted there on the slide, it is common for OMC's constitutions to require this qualification. And of course, as a matter of practice, because directorships for OMCs are largely volunteer positions, it is difficult to attract, to encourage anybody or entice anybody who isn't a member of the OMC and therefore has a dog in the fight from giving up their time for free to fulfill that important and occasionally time-consuming post. As I mentioned, the MUD Act imposes obligations on directors over and above those contained in company law, which still do apply. And those include the obligations on directors to prepare and circulate each year an annual report, and I'll come on to more detail on that later on, to set the service charge budget and then to levy the service charge and sinking fund. But the Act requires, I think quite sensibly, that directors can't be appointed for terms which last for more than 3 years. Now, what that doesn't mean is that after 3 years, a director is done and cannot act as a director of that OMC again. But it does mean that the directors, after their 3-year term has expired, should retire and, if they like, offer themselves to be reappointed or re-elected. And this is helpful because it is consistent with standard retirement by rotation clauses, which are very common in the constitutions of OMCs. So you will very often see constitutions providing that 1/3 of a board of directors of an OMC must retire each year, and if they want, offer themselves up for re-election at the annual general meeting. And so it's worth building that into an OMC's constitution for a couple of reasons. One, it brings it reinforces the obligation in the Act not to have directors having terms of more than 3 years. And secondly, and this is of course the point of the provision anyway, Excuse me. It gives the membership a say in who is managing their OMC at each general meeting, and more detail will be given on this in the specific presentation. But it is always open for members to nominate people who they would like to stand as director at that annual general meetings, and there is usually a provision with the AGM pack for them to do so. And I mention this not only because it's an important provision anyway, but there is case law which relates to the retirement by rotation I mentioned, not specifically to the MUD Act provision, but there is case law which says that actions taken by a board of directors who should have resigned or retired and put themselves up for re-election but didn't may not be valid. So it is an important, it is something which needs to be complied with, because it can, not least because it can have important practical considerations for the operation of the management company. And as I noted, the MUD Act also imposes extra obligations on an OMC with regards to meetings of its members. Meetings of members are referred to in company law as general meetings. And of course, most people on this presentation will be aware that companies and OMCs have to hold a general meeting, a meeting of the members every year, and that general meeting is called the annual general meeting, or the AGM. In addition to that, the MUD Act provides that owner management companies must hold a meeting each year at which the annual report is considered, the service charge budget approved, and the sinking fund contributions, if they're of an amount other than €200 per unit per year, are set. And the Act also provides that there must be at least 21 days notice given of the meeting which considers the annual report, with that report sent not less than 10 days prior to the meeting. And what happens in practice is that the annual general meeting of an OMC will include, in addition to the usual Companies Act business, such as the approval of the financial statements of the company and the election of directors who are retiring by rotation that I mentioned, will also fold in the MUD Act business appearing on the second bullet point there as part of its general everyday annual business. So it's rare that two meetings are held, because two meetings don't need to be held, provided that the one meeting that is held does cover all of the business, and that is routinely done in the vast majority of OMCs with which I am familiar. And I just want to take time just to note as well that at company law, members of a company, generally speaking, take decisions in two ways. The first is by ordinary resolution, and that means a resolution passed by a bare majority, so over 50% of the members who turn up and vote at a general meeting, or by special resolution, which is a resolution which is passed by members holding more than 75% of the votes who turn up and vote at a meeting. And ordinary resolutions tend to be more day-to-day matters, and in fact, every item to be considered at a standard AGM would be passed by ordinary resolution, where a resolution is required. And special resolutions tend to be more fundamental matters, such as changing a company's constitution or putting it into liquidation. The MUD Act doesn't really use the same terminology as the Companies Act. It doesn't deal with resolutions. It mentions decisions and approvals, which are interpreted correctly as being resolutions. But it also doesn't really carry on the provisions of ordinary or special resolutions that I mentioned. And in particular, we'll see this in a bit more detail later, the service charge budget is effectively passed by members holding more than 25% only who turn up and vote at a general meeting, by which I mean that the MUD Act says that where the service charge budget for any year is put to a meeting of the members, it needs 75% or more to vote against it for it not to be approved. And that's not always clearly understood by members or even directors of OMCs with which I deal. So I have mentioned in the context of directors' obligations and requirements for holding meetings that the board of directors of an OMC each year are required to report to the members. Again, this is part of the overarching theme of the MUD Act, of this relationship between developers, unit owners, and the OMC. The unit owners are given the right to receive regular annual information about the management company which has been set up to look after their interests in relation to the common areas. And the Act is quite prescriptive about what the annual report should contain. And I've set out on this slide and the next those items. And they are financial information about the company, and in particular what's standing to the credit of the sinking fund, and what has been and what will be charged in relation to the service charge. The report is required to contain any information about any planned expenditure on refurbishment, improvement, or maintenance of a non-recurring nature, and those, as we will see, what that's getting at, as we will see, is really are you planning on spending anything out of sinking fund? The report is required to include details of the insured value of the multi-unit development and the amount of insurance premium charged, among other details. Details of the fire safety equipment and the maintenance of that equipment, which is of course very important. And any contracts which an OMC has entered into or which are otherwise in force between the OMC and a director of it, or a shadow director of it, or any person who is connected to a shadow director or a director. Now we know what directors are. A shadow director is a person who isn't a director, but is so influential that the board, out of habit, generally always do what that person says. Now is rare generally at company law. It's vanishingly rare in the case of owner management companies. And a connected person in this context isn't fully explored in the Act, but in the Companies Act, which is I think instructive to look at in this context, a connected person would be a close relative of a director, so parents or child, siblings or spouse, or a company or partnership which the director owns or which is owned by the director and or his or her close relatives, as I mentioned before. So there are general company law provisions about directors declaring interest in contracts, and this element for an annual report reflects that directors should let, the directors maybe ought to let members know in the context of an OMC where the OMC is dealing with the directors themselves, or people voting to do them. Having looked at some areas of how the OMC operates, it's worth looking at what the OMC does. And that is, of course, the OMC's primary and in most cases only function is to own and to manage the common areas of the development for which it was incorporated. As I mentioned before, the common areas are required to be transferred to the OMC by the developer, and the OMC has the obligation to repair and maintain those common areas, and as a result has the right to carry out essential repairs to parts of the development which it doesn't own, so the most obvious ones being apartments, in order to effectively maintain the common area. So if the representatives of the OMC need access to someone's apartment to make essential repairs, then the MUD Act provides that can be done. And in order to promote effective and efficient management and cost-effective management of the common areas by the OMC, the Act provides that the OMC may not enter into contracts for the provision of goods or services to it if those contracts have terms in excess of 3 years. And as you will have anticipated there, the idea is that there is a regular pause in proceedings where the management company is required either to renegotiate the terms of a contract they may have with a third party, or to go out to the market to tender, or maybe less formally to find out if there are better prices available to it, with the intention that the service charge is thereby reduced, and that the owner's contributions are consequently reduced also. And the type of contracts that I'm thinking of here are primarily those with the main type of person with whom an OMC would enter into a contract, which is the managing agent. But OMCs may, of course, enter into contracts for the provision of security services, waste management services, window cleaning and the like. So up to this point, we've been looking at the interaction between the OMC and the unit owners, and I'll come back onto that later on as well. But the third element, the third type of entity which is involved in the underpinning relationship of the MUD Act is the developer. And it won't surprise you to learn, therefore, that the MUD Act does impose a fair few obligations on developers. And I've set out a few of those in the next couple of slides. And the main thrust of the developers' obligations are really to set out, really encapsulated by the penultimate bullet point on this slide, which are that ultimately the developer is required to put in place an owner management company which is able to perform its functions and powers for the benefit of the unit owners once the developer has withdrawn from the development, because the units are now all sold on. And as part of that, of course, the developer has to establish the owner's management company. It has to transfer the common areas to the OMC. And as I've noted in bold type there on the last part of the slide, the developer is required not only to transfer the common areas, but to ensure that the management company is legally represented and that the reasonable costs of that representation are paid. Again, the point is that at the point when the unit owners start to take control of the development, they have the means to do so effectively. And part of that, and the main thrust of the MUD Act, is that there is an OMC capable of doing what it needs to do that. Additional obligations imposed on a developer include things like indemnifying the OMC against any claims in relation to anything the developer may have done or not in completing the development, and to put in place a contract of insurance. Now, many of you will no doubt be keenly aware that that doesn't always happen in practice, but it is something that the MUD Act does require. And as regards the unit owners in particular, the developer is obliged to minimize inconvenience to unit owners and to ensure that unit owners themselves have access to the transferred common areas, because what's the point in having an OMC to look after those if you can't access them yourself? There are some rights imposed, rights given to developers under the MUD Act. The most practical, the one with the most practical application, which is the second bullet point there, which gives a developer the right to pass and repass and have access over the common areas itself if it needs to do so to enable it to complete the development, which does happen. So now I want to turn to some of the practical application of the relationship that I've been discussing there between the three parties that the MUD Act deals with, and in particular, really here, the relationship between the owner's management company and its members, the unit owners. And I'm going to look first of all at the main area in which an owner's management company will interact on a kind of yearly basis with its unit owners, and that's in the levying of certain charges from the unit owners in order to fund the management company to enable the management company to do what it is required to do. And the two types of charge which the MUD Act deals with are the service charge and sinking fund. And the service charge is dealt with by Section 18. I would also like to point out as well that, going back to David's introduction, there will be specific presentations on each of these aspects. So I'm not going to go into great detail, and certainly not around the mechanics of what we're talking about, but just to give an overview of what the MUD Act says. So every MUD Act must establish a service charge scheme for the maintenance and repair of the common areas, and it must not make any charge on that scheme unless the members have approved. And the Act says what the service charge can be spent on, and I've listed a few of those things in a subsequent slide, but generally speaking, it's the day-to-day stuff. It's the expenditure necessary, both figuratively and literally, to keep the lights on at the development. But what it cannot be used on in matters which are the responsibility of the developer unless two things have happened. And those two things are that at least 65% of the units at the development are owned by people other than the developer. And what that does is establish that where people need to vote on this, the majority of them are not the developer. And then it requires that 75% of the unit owners, or the members of the company, which are the unit owners, agree in writing to the expenditure. And in a classic multi-unit development, a multi-block or certainly a multi-apartment development with hundreds of unit owners and therefore hundreds of members, not all of whom live in occupation, not all of whom may be in the country, then many of you will appreciate getting 75% of them to sign something is very difficult, to the point almost of improbability. So for those reasons, it is very rare for service charge to be used for things which may have been the responsibility of the developer. The other reason why it's not done is because, as we can see from this slide, the types of expenditure which are categorized for service charge expenditure in the Act are those day-to-day items that you would expect a service charge to be spent on. So insurance, general day-to-day maintenance, waste management, cleaning, gardening, etc. As I said before, figuratively and literally keeping the lights on. Because more one-off and rainy day items are more appropriate for the sinking fund, which we'll come on to. Before we do that, just a word about how service charges are approved, or kind of more accurately for how the MUD Act is set up, disapproved. And I touched upon this on an earlier slide, but in a way which is not generally consistent with more traditional Companies Act requirements. A service charge budget will be approved unless 75% vote or more members in the meeting who turn up and vote against it. So it's an inversion of the usual approval required. Although there is the ability of 60% of the meeting to vote to vary or disapprove a single line item in the budget. And it is unlikely, I've not come across it, but if a service charge budget is disapproved, then the previous year's budget applies. The Act requires that service charges must be calculated on a transparent basis, and that's to some extent where the annual report that we've discussed comes in, and be equitably apportioned between unit owners. And the OMC is required as part of the transparency obligation to maintain records of expenditure to enable verification and audit of a service charge from time to time. So the second type of charge which the MUD Act entitles, and in fact obliges an OMC to make from its members, is in relation to a sinking fund. And Section 19 of the MUD Act obliges OMCs to establish a sinking fund in relation to their development, from which money can be spent on refurbishment, improvement, maintenance of a non-recurring nature, or advice from a suitably qualified person in relation to any of those three categories in relation to the development. And of those types of expenditure, the board of directors of a management company can authorize the expenditure on refurbishment and on improvement and on the legal advice without having to go to the members, although that doesn't preclude them from going to the members if they want to. But where a company wishes to make expenditure on maintenance of a non-recurring nature, then that must be certified as such, and then by the directors. And after the directors have done that, then it must be approved by the members in a general meeting, and that's by an ordinary resolution, because it doesn't say special, basically. And the Act does give some indication as to what it means by maintenance of a non-recurring nature, and that is expenditure which relates to a matter on which, maintenance on a matter on which expenditure is not generally incurred in each year. So we are talking, as you would expect, given the reason for having a sinking fund, these are one-off, not day-to-day expenditure. So the lifts have broken down, a storm has blown the roof off, that kind of thing. And the Act sets as a default that sinking fund contributions are €200 per unit per year. Now, this can be set higher by the OMC, but only if the members approve that by an ordinary resolution. And it can also be levied in disproportionate amounts. So some units pay different rates to other units, if that is equitably done. And this relates back to the requirement for equitability in the sinking fund calculation. Sorry, the service charge calculation, I beg your pardon. And the MUD Act requires also that a sinking fund is held in a separate account from general day-to-day monies. Again, the idea being that these are ring-fenced funds for a rainy day and not, generally speaking, to be mixed in with a service charge, so that there's less, there's always kind of segregation between the two. Finally, on sinking fund and service charge, the MUD Act says that an OMC can collect levies properly incurred under those provisions as a simple contract debt in a court of competent jurisdiction. So the OMC can go to court to make a claim for service charge and sinking fund charges as though there were a contract in place between the unit owner and it for the payment of those amounts. The MUD Act also has provision around house rules at developments, which is set out in section 23 of that Act. These are optional. There's no obligation on an OMC to have them. In my experience, they tend to be fairly commonly used, and they tend to be quite popular as well, I think. So with that in mind, I was going to spend a bit of time talking about them. And in particular, what the MUD Act says the purpose of these should be. And so the Act says, and this is the third bullet point here, that house rules should be put in place with the intention to advance the quiet and peaceful enjoyment of the property by, and to fairly and equitably balance the rights and obligations of the occupiers and the unit owners on the one hand, and the company on the other. And you'll see there that house rules can apply not only to unit owners, but also to the occupiers of the premises, if those occupiers are not themselves the unit owners, which of course makes sense. What's the point in telling someone who doesn't live there not to put their bike in the corridor? And so, and then, as you'll see from the final bullet point there, that is backed up by what the MUD Act says as to what the OMC can recover in relation to any breach of the house rules. And what the Act says is that the company may recover the reasonable cost that it incurs in remedying a breach, again, as a simple contract debt in a competent court, the same way that it can for sinking fund and service charge levies. Now, those two items I've mentioned there are quite intertwined, and it's important, I think, just to emphasize that the house rules are not there to punish members. They are there to establish a framework that the members can enjoy communal living in a way that doesn't impose unfair obligations on anyone. It is reasonable to expect people to put their rubbish in the bins and not leave it in the corridors of the common areas. It is reasonable to expect members if they're to clean up after their pets, let's say. It is not reasonable to fine members. So if, as I've said, if the OMC wishes to, if there is a breach and the OMC has to do something to remedy the breach, it can charge the cost of that. What it can't do is slap a fine on members for breaching the rules. Set them out. And house rules can only be adopted, or once adopted, amended, if they're approved by a resolution of the members at a meeting convened on 21 days notice, and the draft rules have to be sent out with that notice. So we tend to see in practice that house rules, unless there is an emergency, tends to be folded into the general AGM business, because the 21-day notice period lends itself to that, to resolutions being taken at that kind of meeting. So one of the final things I want to look at is what the MUD Act says about dispute resolution. And Section 24 allows a wide cohort of people who bring claims in the circuit court for any such order as the court considers to be just and equitable. And as you would gather from that kind of wording, that is very, very wide discretion. So provided you are the type of person who can bring a claim, and at the final bullet point there, we'll see that section 25 of the Act says that that type of person is the OMC itself, any member of the OMC, so therefore a unit owner, the developer, or such other person as the court sees fit. Now, presumably, that other person would need to show to the court that they had good reason for bringing the claim. But nonetheless, it's not just limited to those, shall we say, stakeholders of development. It's potentially anybody, and they can bring a claim for any order that the court considers is reasonable, or just and equitable in the circumstances. And the Act itself does set out a fairly long list of examples of what type of order can be brought. Although that is not an exhaustive list because of the wide discretion I've mentioned. And in particular, the one I've flagged is that the court can and has, I think to my knowledge, made orders that where the constitution of the company either precludes it, or where the company is being operated in such a way as to deprive members of their statutory voting rights that we mentioned before, the court can make an order that the voting rights are as they should be, and that residential members get one vote for every unit that they own. Now, as I mentioned before, I am not by practice a litigator, so I don't have practical knowledge of the frequency of these types of claim, what they cost, or how long they take to reach a judgment, or indeed how successful people are in bringing different types of claim. But I do know that it is available, and what is available is quite wide. Just to follow up on that as well, the Act does provide that in addition to the general kind of alternate dispute resolution mechanisms which are available at Irish law, the Mud Act specifically says that on an application having been made under section 24, the court can order that a mediation conference be made, which strikes me as being quite sensible, given that it's likely that any kind of disputes will involve neighbours. And neighbours' disputes, for anyone who's kind of unfortunate enough to have been involved in one, tend to be very personal, and so mediation may be a better way to diffuse tensions running high in those kinds of plans. And you may or may not be pleased to know this is the final thing I want to talk about this afternoon, which is that the Mud Act provides for circumstances where an OMC may be restored to the register after its dissolution, which go above and beyond the normal rights which are contained in the Companies Act and in general company law. And just by background, every company which exists in Ireland is registered with the Registrar of Companies, and it's possible to go along to the company's registration office online and for a small fee to find out information about that company. And every company is required to make annual filings of an annual return and financial statements, unless certain exemptions apply. If a company does not make those filings, then after a period of time and after several warnings, the CRO has the right to dissolve that, to strike that company off the register, to say, you aren't playing by the rules, you no longer deserve to be on the register, we'll strike you off. And then what happens as a result of that is that the company is dissolved and no longer exists. And what that in turn means is any property which belongs to the company passes to the state. So as you might imagine, where an OMC has been established and where the common areas have been transferred to that OMC, where the OMC is dissolved and the common areas therefore pass to the state, that's not a particularly great state of affairs for the development and the unit owners to be in. So the Companies Act provides for a couple of methods for restoring a company, one of which is administrative, and that's available in the first 12 months after dissolution has taken place. And that's a simple application to the CRO explaining who you are, why you are in a position to make the application, and why you want the application to be made. But after that 12-month period has expired, then there is a further 19-year period where application can be made to restore the company, but only by going to court, which of course comes more effort, more delay, and more cost. What the MUD Act does, it recognises that owner management companies, and particularly the property which they are required to own, are important to a great deal of people who may, and almost certainly are not, responsible for the company having been struck off and dissolved. So the MUD Act extends the initial 12-month period in the Companies Act for administrative restoration to 6 years. So if anyone here is a unit owner at a development and is worried that there doesn't seem to be an OMC, even though there once was, then this may be something that you can avail of. And that, I think, is bringing us up to the allotted time. And that's all the slides I have to share with you. So thank you very much for bearing with me there. I hope that was interesting. And I'll stop sharing now and hand over to David.
Great. Thank you very much indeed, Nick. So in terms of our timetable, we're just coming up to 1:30, and we have received a great many questions both in advance by email, and we'll get to those, and also in our Q&A function. And thanks indeed to those of you who have submitted questions to the Q&A. We have endeavoured to answer many of them in real time and keep up with them to the extent that we can. And indeed, I think it's important to say, as I think Nick has said in his presentation, that today's session is on the MUD Act, and there are 5 further sessions on the following Wednesdays until mid-August, which will deal with many of the questions that indeed have been raised in the Q&A. But that said, there is crossover between all these issues as well, and there's multiple pieces of law that answer multiple questions we have received. So perhaps, Nick, what we might do is we might go to the questions we received by email in advance, on the basis that, I suppose, first come, first serve. And the first question we had received was, what does Section 3, subsection 2 of the MUD Act mean? Does it mean that for the section to apply, both subsections 2A and B have to apply, or does it mean the section applies if either 2A or B applies? So I think this is a question on developers, isn't it?
It is, yeah, and Section 3 generally, and I touched upon this on one of my slides. Section 3 is the section which sets out the main obligations on the developer as regards establishing the OMC, transferring the common areas, etc. Section 3, subsection 2 states to whom that section applies, and it applies. And what subsection 2 does is to say basically that it applies to developers of developments where residential units, the first residential units are sold only after the coming into force of the Act, because sections 4 and 5 then deal with developments in which units had already been sold prior to the Act coming into force, which you have to forgive me, I presume was in 2011, but it would have been there or thereabouts, given that's the date of the Act. They don't always come into force at the same time as the date. And so, in a specific answer to the question, it's phrased, that section is phrased as being this and that, but what it means is it applies to either or both of the type of person mentioned if they are in place in relation to the development in question.
Okay, very good. Thank you, Nick. The next question we received by email, and I can see just in the Q&A that we have 30 questions. So I hate to disappoint people, but we couldn't possibly get to all the questions we're getting in. So an option for people whose questions are not answered is to send an email to mud@housingagency.ie, and I'll put that email address up at the end of the session. But the next question we received in by email is, what is the definition of connected person in the context of Section 17, subsection 2, paragraph 1 of the MUD Act?
Yeah, and again, I did touch on this a little bit in the slide, so it's a good question because it was one that I myself was asking. But in this context, so the MUD Act itself doesn't define connected persons. So given that, and various bits of legislation do to varying degrees, but given that, as I was establishing in the presentation, or hopefully establishing in the presentation, given that the idea of the MUD Act really is to establish this relationship for the management of the common areas of the development through a management company. It's probably instructive to look at the definition of connected persons as that's contained in the Companies Act. For what it's worth, it's section 220 of the Companies Act, and that's not that important. And that is, as I mentioned in the talk, generally speaking, the context of a director, and that specifically, in fact, that section specifically relates to persons who are connected to directors, not connected to people generally. And in that context, it is close relatives of directors. So, as I said, lineal descendants and ancestors, lineal relations, sorry, so parents, grandparents, direct issue, children, grandchildren, siblings and spouses, and then companies or other entities like partnerships who are controlled by the director, him or herself, or by persons, individuals connected to that director, who are the people I just mentioned, or a combination of those people. So if, and of course 17, the section that this is about is around, or it is used in the context certainly of owner management companies entering into contracts with directors and persons connected to them. So the annual report is required to state where an owner management company has not only entered into a contract for the provision of services with the director personally, but also with that director's business. So the point, I mean, I mentioned this in the slide, I won't be telling you anything that you don't already know. The point is just so the members are made aware where a director is receiving a payment by the management company, and that I ought to say that is not in itself manifestly sign of anything wrong or anything like that. It may be the fact that a director of the management company, properly appointed, owns a plumbing business and may have offered discounted rates. So the management company needs some plumbing doing, why wouldn't it enter into a contract? It's not in itself a bad thing, but it is something which the MUD Act, I think correctly, thinks that the members ought to be made aware of.
I suppose it's something that'll come up in the context of the company law presentation and conflicts of interest and directors' duties. There's nothing wrong with a conflict of interest, provided it's disclosed, discussed, and resolved. Is that fair?
Absolutely. It's in many cases. I mean, in the context of an OMC, where, as I mentioned, the directors are very likely to be unit owners, there's an inbuilt conflict of interest. Conflicts, as you said, David, are not bad, but they do need to be recognised, and people need to be made aware of them.
Okay, thank you for that. Moving on then to the next question we received, which I think you actually answered in your presentation. Who can become a director of our OMC? Can fathers, sisters, and sons become directors of an OMC? And the questioner then gives a particular scenario, which I perhaps won't read out, just I suppose to protect the anonymity of the case. But I think you've dealt with that in your slides.
Yeah, and just to recap, and what I didn't say in the slide is that what the Companies Act says is that any person over 18, any natural person, any individual over 18 can be a director of a company. Companies themselves can't be directors of other companies, and minors, people under 18 can't be directors either. But other than that, and the MUD Act doesn't change this, as I said, anyone can be, or people who have been disqualified or restricted by the Director of Corporate Enforcement, of course, won't be able to be either. But generally speaking, anyone can. They don't even have to be members. It tends to be the case that they are, for the reasons I discussed. And what there should be, because both of the 3-year term rule in the MUD Act and the general provisions you tend to see with owner management companies anyway, what there should be is a process every annual general meeting where at least a third of the board is up for re-election. And if the membership is either unhappy with who their directors are, or if if there is someone who would like to go on the board, who the members would like to see on the board, then there is a mechanism which is set out in the Companies Act and not the MUD Act, and we will discuss it in more detail at the company law session in 3 weeks' time, I think, David.
Okay.
There is a mechanism whereby members can nominate people and have them put up for election in certain cases at general meeting.
The next question that came in was, is any information available on the experience of OMCs in recovering service charges by legal proceedings? And I think the answer to that is tune in to our session on the 21st of July, where we will have a detailed consideration of service charges and debt collection. So if you haven't registered.
Yeah, yes, somebody with way more expertise in that area than me will be delivering that one. So
very good.
Yeah,
and the next question that came in by email, and we've one more after that, is have any written judgments been delivered by the courts relating to the recovery of service charges? Again, we'll discuss that on the 21st of July. And the final question we received in advance, are there any sanctions in legislation to deal with the failure of agents to perform duties in common areas? And our session on the 11th of August, which is role of the management agent and the PSRA, will deal with that in considerable detail. So we'd invite questioners to register for those sessions. And just a reminder, as I mentioned at the outset, registration for today's session doesn't get you access to the subsequent webinars. So you do need to register for each individual webinar, and you will receive a separate Zoom link to allow you to attend that session. Full details again are on our website, housingagency.ie, under our news and events page. So if you have any doubt, pop onto the website and look at the details there, or indeed email us mud@housingagency.ie, and we'll come back to you on that in terms of the schedule of events upcoming. So I'll go now to the questions that have come in, which are very wide and varied questions that have come in as we've been on air, so to speak. We have about, give or take, 10 minutes to try and deal with at least a number of those. And again, apologies, just the sheer volume of questions, I think, shows the interest and shows the appetite for information out there. Sheer volume of questions means we won't unfortunately get to all of them, but please do email us in. And I will pop to some of the questions there. So an interesting one was in relation to units that aren't necessarily residential units. So a question is, should owners of parking garages that form part of a development but are not owned by apartment owners be considered members of the OMC? They do pay a service charge. So I think that might come back to maybe consideration of the actual lease in the development.
It might do as well, and to some extent as well, the definition of units, which the MUD Act really it doesn't say there's many words, but the implication is that it's a kind of self-contained unit that, as you would understand it, a house, a shop, that kind of thing. So it may be that the MUD Act doesn't really anticipate that or deal with it, which doesn't mean that the owner of the car park couldn't be. I think David is right that you might have to look at the leases. The constitution of the company itself might also give some clues to that. But it's not really the focus of the MUD Act, certainly.
The next question is, would you confirm that the sinking fund can also be less than €200 per unit per annum, e.g. for a private housing estate?
This is a good question. It's one that does come up in practice a fair amount as well. And my answer is going to be maybe a standard lawyer's hedge on this one. So the Act itself says it's 200 units or such other amount. So that would imply, yeah, up or down. But what I'm going to say to that is that sinking funds are a very good idea. The Act, not for nothing, does the Act require an OMC to put one in place. And what I do understand, and this is outside of my area of expertise, but I am aware that the common practice for managing agents is to conduct what I think are called life cycle reports for developments, which of course analyze the development over 10, 20 years or whatever it may be to try to ascertain what is coming down the pike. And the results of those that I have seen, and you know, I'm only tangentially involved, and so tend to show that, yeah, look, of developments of any kind of age, if you look far enough in the future, there's going to need to be stuff, something happening, and depending on the age of development, of course, that's more acute. But what comes from that, it's not always acted on. What comes from that is a recommendation, at least, that more than 200 quid is needed. So, yeah, it's probable under the Act that you could go for less than. It doesn't seem to me to be very recommendable, but there you go.
Certainly tune in to our session on towards the end of our program on sinking funds, and we'll go into that in much more detail. I see a question that came in. Any recommendation on what to do with top debtors? Can we sue them? Is that under the MUD Act? Again, please tune in to our session next week on service charges and debt collection. I'm just scrolling through questions here as I see them. So we see a question: if the management company is dissolved and the common areas are registered in its name, can the council take over the estate, or have they the power to do so? And I think that's probably a question that is a combination of a planning matter, and it's also a question of possibly seeking the reinstatement of the management company.
That would be the method that I would explore first. How long ago was the management company dissolved? How easy is it to get it back on the register? Because technically, I guess, well, not technically, the common areas are with the state. I am aware, and I don't have much detail on this, I'm aware of some success of going to court and making an argument that, okay, that management company was gone. The common areas were owned by it, but it was kind of owned on trust for the members. Giving them this on trust, maybe the state don't own it. We've got a brand new shiny management company that all the members like. Can the court order the trust be moved over there? That has a certain type of name, does that order? I'm really sorry, I can't remember it. It's like the surname of someone who first brought the claim. So there may be a way around it if it's not if it's not that practical to reinstate the company. But as with anything else, you should take specialist legal advice in relation to that.
Yeah, I think it was the Heidelstone case, and then there was a more recent one only last year, Barnafarga, in relation to a holiday estate in County Mayo, where that application of the Trustee Act was brought in. So there are options, there are legal options around that. So I'll just persist with a number of other questions. So a question that came in was: can a unit owner stop their service charges fees? Stop paying their service charges based on the fact they're not happy with the management company services, e.g. they would like to see more common areas cleaned?
Not under the terms of the MUD Act, no. And not if the service charge was properly approved in the manner that we were discussing in the talk there.
Yeah, exactly. I think subsection 10 of section 18 has specific provision to say you must pay your service charge, and equally the lease, when you sign your lease, you're covenanting to pay the service charge as well. So I think that's quite clear. A question on house rules. When it comes to the house rules, when a resident keeps breaking the house rules even after letters of warning have been sent, is the next step to go to the residential tenancies board? And maybe, I suppose, there's probably a sequence or a tiering of escalation, probably first to try and resolve things in a soft way between parties, then go to the MUD Act and subsection 11, section 23, so the administrative costs. I think the RTB does have an option for third-party dispute resolution. So if the OMC is having difficulty resolving matters between a landlord and a tenant, they can certainly bring the RTB to bear. Would you have any observations on that?
I'm only really to echo what you just said there, David, that isn't quite within my area of everyday practice. I've no day-to-day experience of that. That tends to get pushed over to the real estate and dispute resolution teams. So yeah, but what you said there, I think is probably the way to go.
What do you do if the developer never transferred the common areas as part of handing over the OMC?
This is not as uncommon as you would hope it would be. So it is an obligation. It is a statutory obligation of the developer to have done so. And so the developer, if they're still around, should be approached and requested to do so. But if they don't, and they are still around to get after, the potentially unadvertising procedure is to bring a claim against them to enforce the OMC. If the OMC doing is to enforce the OMC's rights.
So essentially, you'd have to retain legal advice and go to the circuit court to seek an enforcement order.
Yeah. I mean, the first part of that answer is the most important one. Retain legal advice. I am not a litigator, and so you should definitely take specific legal advice around that. And a specialist will be able to give you much more tailored advice on that.
A member who is in arrears does not have a vote in our OMC. The Constitution is silent on whether the member can attend an AGM or EGM. What's the situation? That's probably a confluence of the Companies Act and the MUD Act.
Yeah, it's mostly Companies Act actually. So the default provisions for companies generally actually, but certainly for companies limited by guarantee, is just that if you owe money to the company, you lose your right to vote. But that is money immediately payable. It's not you haven't paid your service charge yet, but you haven't been invoiced for it either. There has to be kind of, you've been asked to pay, you should have paid, you didn't. So if the Constitution doesn't have it in, the Companies Act will probably imply it, but you need to have a look at the Constitution just to make sure what the exact wording was. And it's not, because it's in the Companies Act, it's not therefore, an unusual or particularly unreasonable thing. It's been a kind of standard part of company law for a long time.
A question then, I think it's probably dealt with in what we've discussed earlier. If a director sells his or her apartment, does this mean he or she has to retire from the date the property is sold?
No. You would expect that they would, because why would you stick around? But no. Again, directors do not have to be members under the MUD Act. The Constitution often does change that. In which case, yes, the director would be almost certainly have just automatically deemed to have retired, and the company should do the necessary filings and so on. But no, under the MUD Act, no, it's just membership that goes, and membership isn't linked directly to directorship.
We have a number of questions that come in on the house rules and the recovery of costs, and I think you might correct me on this, Nick, but I think it's fair to say that what you're dealing with under that provision, which is subsection 11 of section 23, it's the recovery of costs associated with breaches of house rules. It's not the levying of fines. So you can't fine someone, only the courts, I think, can fine. Is that right?
You can't fine someone under the MUD Act, certainly. I would be loath to, I would be reluctant to advise anyone to put themselves in the place of a state authority and say, we have the ability to fine you. Again, this isn't my area of expertise as regards to the claiming of money, but generally speaking, you shouldn't be, private actors shouldn't be penalising people.
Yeah, so I think it's probably the case that if there's a security call out charge for, heaven knows, parties on a Saturday night at 4 a.m, that security charge can be recovered from the owner of the offending apartment or house. I think that's the idea. Certainly.
I would like to stress it's the MUD Act that doesn't provide for fines. MUD Act just says you get your costs.
Exactly, yeah. Look, we're coming up to 10 to 2. We have a raft of other questions, and I do apologise to our questioners. We just, with the sheer volume of over 360 people, I think, attended the session at the height of it. We weren't in a position to get to all the questions. So if people would like to send their queries into us to mud@housingagency.ie, I'll put that up on screen here, and hopefully you can see the slides, which we will send out by email. I've already mentioned our session next week, service charges and debt collection. So same time, same place, same channel, as they say. We would ask you, if you haven't registered for that, or if you haven't registered for subsequent sessions, to please go onto our website and do so. We do have a suite of resources on our own website, which is housingagency.ie, where you'll find answers to frequently asked questions. You'll find links to legislation to which Nick has referred. You will find links to a number of different bodies involved in the sector, and hopefully that information will be of use to you and supplement what we've already gone through here this afternoon. And finally, I would draw to your attention our guide for owners management companies, which was I popped it up on screen there, which was issued in conjunction with Chartered Accountants Ireland only in May last year, or May of this year rather. Owners management companies, a concise guide for directors, so you can go online and access that, and it deals with things like directors' duties, board effectiveness, and that's some of the issues that will be covered in the company law presentation later on in our series. So look, respecting everybody's time and to all those who attended, we're very grateful to you for your attendance today and for all the questions. And again, renewed apologies that simply time didn't allow us to get to all of those questions. But we thank you for your attendance. We will make this recording available on our website. As I say, the slides will follow, and we look forward to seeing you all again at 12:30 next Wednesday lunchtime, Wednesday, the 21st of July, for our session on service charges and debt collection. So thank you very much indeed, and we'll say goodbye and wish you a good afternoon, and thanks indeed to Nick as well. Cheers. Bye-bye.